Karen Read and her defense team appealed to the Massachusetts Supreme Court after jurors had come out stating that they actually acquitted on counts 1 and 3 that she was initially charged with. It has been a few months since we heard the hearing of this case, and now we finally have a decision coming from the Massachusetts Supreme Court. And frankly, I'm not surprised. Let's get into it. Now, if you are newer to the case, you may not know what happened at the end of last trial. Karen Read had 3 counts against her, and the jury as a whole couldn't come together to get to a final count. So it ended up in a hung jury where Bev actually ended the mistrial like that. So the reason why we had an appeal was because jurors afterwards came out and said, no, we acquitted on counts 1 and 3. It was actually count 2 that we were hung on. This is why we had the appeal to the Supreme Court. Something I found interesting in one of the footnotes in this, it states, the record submitted to the single justice and now before this court does not contain transcripts of the testimony or the exhibits from the defendant's first trial. I do believe if they had actually included some of this in the actual appeal to the Supreme Court, that, more of the meat and potatoes of the trial, that this might have affected them for the better, but unfortunately it wasn't supplied. The reason why I say that is because it's even noted here in the second page where it states the trial was lengthy, spanning 8 weeks of evidence involving 74 witnesses and 657 exhibits. Can you imagine the things that they could have included, at least the most important or controversial things, like inverted videos? Because I believe if they had included the fact that there was still missing video footage of her murder weapon, her vehicle, this would have helped this statement where it says that the defendant does not contend that this evidence was legally insufficient to support a conviction on any of the charges. What I personally found out of all 35 pages is that the court is taking this as fact. They're not looking into any of the other extracurricular things. They just looked at they were given, and that was that. They state that the jury clearly stated during deliberations that they had not reached a unanimous verdict on any of the charges and could not do so. As a reminder, jurors came out to say that they acquitted on 1 and 3, but because the jury foreman wrote down that they were hung, that they didn't actually say, hey, we are acquitting on 1 and 3, the court doesn't see it like that. The court just sees, they didn't acquit. They were hung on everything. And they actually blamed Karen's defense team because they state at no point during this discussion did defense counsel object to the judge's declaration of a mistrial or express disagreement with that outcome because they had no fucking chance to. She just said, we're done. Goodbye. Peace out. And it was after Judge Cannone got Karen's original appeal and she denied it. That's the reason why they went to the Supreme Court. She called the team shrinking violets. They were no shrinking violets. In another footnote, they state the defendant has not argued that the evidence presented at her first trial was legally insufficient to sustain a conviction, and thus we do not address the issue. It's almost like they're trying to state, add in more of this because we could have ruled on this had you given it to us. Furthermore, because of the way that the jury foreman's note was put, it was very specific, and that is what the Supreme Court is ruling on. That is the reason why this ruling happened. And another footnote, that the jury notes provided, quote, no inkling of agreement on any of the charges. Further into the explanation of the decision, they literally state, for purposes of this discussion, we similarly proceed from the assumption that the affidavits are accurate, meaning all of the jurors that came out, they believe them, which makes me raise all of my fucking eyebrows. But even though they agreed that the jurors were right and that they may have actually acquitted on counts 1 and 3, they're not gonna get a juror inquiry. They're not gonna do it. Things like this that make me go, huh? They explained it that they want to maintain the secrecy of the juror deliberations. Again, they're not asking about the deliberations. They're just asking about the final. So if you haven't guessed by now, or if you haven't heard, Their final conclusion: for the reasons stated above, the trial judge correctly denied the defendant's motion to dismiss and request for a post-trial jury inquiry. The case is remanded to the county court for entry of a judgment denying the defendant's petition for relief. The Massachusetts Supreme Court denied Karen Read, and guess what they're going to do now? Fight back. Karen Read's going to appeal them, and they're going to take it up to even higher court. I called this because looking at the hearing and how it went with the Supreme Court, I knew they were going to rule like this. And Karen and her team are not the team just to give up. They're going to bring it all the way up to federal court. Stay tuned for that, because this is going to be literally the trial that never ends. And free Karen Read.